Morning, Your Honors. First, thank you for the honor and privilege of allowing me here to argue this morning. Now, in these hallowed halls, every lawyer in this room has dedicated his or her professional life to the proposition that it's the collective wisdom of the jury when evaluating the credibility of witnesses and sifting through the facts, that's superior to even the most able and well-intentioned jurist. And it's on that foundation that this court recently reminded us in the Cuevas case of the constitutional foundation of what we all do. When you stated, in our constitutional system of civil justice, the jury, not a judge, is charged with the responsibility of deciding the merits of a civil claim. And it's on that foundation that this court has established the rule of law that requires a trial judge to ensure that the expert testimony has a proper evidentiary foundation, while leaving to the jury the determination as to whether the expert's opinions should be accepted or rejected. It has been the wisdom of this court that it is beyond the prescribed role of the trial judge to independently evaluate whether one accepted methodology is superior to another accepted methodology, or whether the opinions of one expert in the court's view is stronger or better than the other. And to Justice Alvin, just to address an issue you raised before. So on this side, we talk about epidemiologic studies that are subject to criticism. Do they have the proper latency? Over here, you have all of the other type of evidence. Animal studies, case reports, biological plausibility. You know, they proved scrotal cancer occurs in chimney sweeps on the basis of one case report. And what happened here is what was not supposed to happen. What happened here was the trial court took one set of methodology and totally discounted the other methodology, when the proper thing to do, I respectfully submit, was to say, look at the body of the methodology and issue. Is there enough here to go to the jury? You know, it's a tribute to our court system.
What is your view of the gatekeeper role then? Based on the argument you're making, what exactly is the gatekeeper role position?
The gatekeeping role of the trial judge is to make sure that the court, that the expert is applying an accepted methodology in coming to his or her conclusions. And they can look at those, they can look at the studies and see if that is happening. But what happened here, I submit, is something that was not contemplated. And if you look at our trial courts, every year it's a tribute to our system how few cases come before you and before the appellate courts concerning the admission of expert testimony. Every year, thousands of cases are resolved under the premise of satisfying the integrated and coherent law that this court has guided us on in Rubanik, Landrigan, and Kemp. And the procedural safeguards that you have put in place with the Kemp 104 hearings, they should not be thrown out and discarded. They are working. They are not mini trials. That's what the defense would like. The purpose of a Kemp hearing is to determine whether the information relied upon should be admissible, not to assess credibility. And at the end of the day, there was a lot of credibility assessment going on here that we submit went beyond the role of what a court should do. A court, I mean, you look at the opinion and it calls the plaintiff's lawyers hired guns. That's a red flag that the trial court has gone beyond its prescribed role and gone into issues of credibility and not admissibility. This Supreme Court, this court's own committee, studied this issue very delicately and extensively and came to the conclusion that our courts are consistently applying the standard and doing it correctly. On the other hand, Daubert, with its best intentions, if you really look at what's out there, the interpretation of Daubert has created varying and inconsistent results. We submit that our law is clear, it is fair, and in its practical application, which is something we need to think about, is far less time-consuming than dealing with the Daubert standard. If you adopt Daubert, it is almost invariably will happen that the lawyers on both sides of this podium will pummel the trial court every time there's an expert challenge with decisions across the country with inconsistent interpretations to in their best advocacy, get where they want to be. That does not mean that a court could not look at a Daubert factor and say, well, for example, was this a peer-reviewed article? That is an accepted methodology. But that's not new to our system of justice. The courts has always looked to see if there was a peer-reviewed article or not, or whether an animal study has been accepted. We have cited a number of studies to you that clearly demonstrate the burden that has been created on state courts that have adopted Daubert and tried to wrestle with all the interpretations that have come before it. And the number of cases where the courthouse doors have been closed to people who are injured who would otherwise have had the ability to get to a jury. It is very telling, I submit to the court, that in its reply brief to our brief, and maybe flattering, that Roach actually admits that our law is fair and that there is no need to change the expert standard to resolve the merits of this appeal. And I quote from their brief, this court's decisions in Rubanik, Landrigan, and Kemp already provide a fair pathway for the introduction of novel scientific testimony. So, in terms of the rule of law, there's nothing broken that needs to be fixed. What we have is working. New Jersey law properly balances and respects the role of the jury and the role of that you've imposed on the court in evaluating whether a methodology is the type relied upon by other experts in the field.
Are you saying Daubert is not as accurate as the test we use now, Rubinek and Fry?
What I'm saying is the tests we have now provide clear guidance, and they are fair.
Well, the reason I asked is earlier you said Daubert would keep people with legitimate claims out of court. I'm assuming from that this would be the converse.
I think because...
Are you saying that Daubert is a lot more stricter than what we have and would keep more people out? Is that your opposition to it?
Yeah, I think in its original intent, that wasn't the case. But in its interpretation and how it's been interpreted in varying places, that is in fact what has happened. The way Daubert has been applied, and we gave you that little map in our brief to show you that it's not always the same, but the way Daubert has been applied, it has encouraged, depending on the interpretation the court cited, it has been applied to encourage courts to cross over from the line of evaluating whether the methodology is sound to actually resolving questions of fact and looking at credibility.
Can we forget about Daubert for a second? Can we improve upon our jurisprudence and give further guideposts that would channel the discretion of our judges? Maybe incorporate some of the factors that some of the cases have elaborated on with respect to Daubert?
Your Honor,
go ahead.
Justice Alvin, I believe they're already there, They're written into our decisions. Our courts are doing a great job of applying what's there. Look at our history. And
So of those factors were further articulated, then your response is we would be doing nothing new.
you would be doing nothing new. I think it's already there. In this context, I submit, or we submit, that the court should determine here whether the trial court faithfully followed the rule of law that you've so clearly set forth, or whether they crossed over the line, whether the trial court crossed over the line and usurped the role of the jury. That, I think, is the core question when you listen to both sides. We believe that if you look at everything that happened, yes, the court was well-intentioned. Yes, the court worked really, really hard. But the court did blur the lines. The court evaluated credibility and not admissibility. It did look at admissibility as well. But when it starts saying this kind of study is better in this context than this kind of study, and then they try to get in, and the court tries to get in that bridge between the methodology and the conclusions, the court here went too far.
Isn't that exactly what Daubert in its present iteration with the additional words added to the federal rule requires in application? It's not just that an expert identify a sound methodology that's recognized for use generically, but how that sound methodology is being applied to the facts of the case. That has to be shown to be done and reliable such that other researchers would agree that they would do it too. Do you agree with that?
I think there are courts that have said that that line should be crossed. I don't believe that was the intent.
That's in the federal rule now.
I don't think the federal rule says that the court should be weighing the credibility of experts.
I'm not saying credibility. Applying the soundness of the so-called methodology that is being identified by the experts for use in this matter, and whether it is being applied reliably in this particular case. That is part of the totality of the analysis that, as I understand it, the federal rule requires.
And I don't really see that this court's precedent changes that very much.
Okay, so you
Okay.
agree with me that that should be done.
I think I do agree that, and that's why I say our law is not broken. But I do believe that in its interpretation in various jurisdictions, depending on the court and the context, that Daubert has created inconsistent results and that the standard has not been integrated and coherent. We have an integrated, and we led the way. We were long before Daubert. We led the way. Our judges know how to apply this law.
So just to be clear,
Maybe not.
are you saying that there's no difference between our current jurisprudence and the federal rule of evidence on expert testimony in its 4 factors, A, B, C, and D?
I think the intent is the same. The problem is that when you say you're adopting the Daubert standard, you are injecting 50 state interpretations.
I'm only asked you whether or not the factors, as they are articulated in the federal rule, are any different than the principles that already exist in Kemp, Landrigan, and Rubanek.
The factors that are in the federal rule under Kemp, Landrigan, and Rubanek may be considered.
But you agreed, or you said in answer to Justice LeVecchia's question, that the trial court here, our trial courts, do a terrific job of applying our standard, which includes a finding that the methodology was applied to the facts in this case in a sufficiently reliable manner, correct?
Yes, Your Honor.
And yet here, the trial court said, based upon all of the evidence, the standards, the testimony, not necessarily credibility, but based on the standards that I have before me, the application is not sufficiently reliable. You didn't cross that threshold. She applied that well-established law in a way that our trial courts do every day and came up with a different conclusion. What's the problem?
Because what happened here was you had a number of methodologies that were competing, so to speak, for getting to the end result. What the trial court here did was totally discount a set of methodologies, more than one I might add, that were reasonably relied upon by experts in the field, that their own experts agreed were reliable, totally discounted those.
And that was Mr. Buchanan's argument.
Right, and only accepted one methodology. Now, if it is true that a jury would would accept the criticism of that methodology, for example, because the latency wasn't long enough, then what actually happened here was the trial court rejected all the methodology that could be considered by a jury to come to a conclusion. And that's why when I started and I said the collective wisdom of the jury matters, because the jury would have listened to the criticisms of our experts or their experts on cross-examination. They would have listened to the criticisms of those experts, because now you have methodologies that everybody agrees were accepted. And what happened here is the trial court drew the line and said, your methodologies I don't accept, your methodologies we do.
In this setting.
Yes.
In this setting, as applied to these facts and what we know, the trial court said he did not find the application of that methodology to be reliable.
And I'll ask you to draw your argument to a close as you answer that question.
Isn't that correct?
The court did say that.
Yes.
I don't believe in practicality that's exactly what happened. What the court did is they only accepted one methodology and then looked really at credibility and made credibility findings concerning the plaintiff's experts, and that's the line that you've always drawn, and we should continue to draw. Our law is not broken. We don't need a fix. Our judges are doing a great job, and respectfully, this court has done a great job in giving guidance to our courts on how to proceed. Thank you very much.